You've felt it. That low hum of unease when you hear about checkpoints, agents pulling people over miles from any border. You assume it's happening somewhere remote, to someone else. I am Felix, and right now 2/3 of Americans are living inside a zone where your constitutional rights apply differently than you think. Not weaker in theory, weaker in law, and the reason it exists will surprise you. By the end of this, you'll understand why it's never been fixed, and that answer is stranger than the zone itself. Here's what you picture when you hear the border, a fence, desert, a crossing point somewhere in Texas or Arizona. That's where border rules apply. Everything else is just America, with all the protections that come with it. Here is what the federal government's own regulations actually say. Under a regulation written by the 1953 Department of Justice, Border Patrol agents hold expanded authority within a reasonable distance from any external boundary of the United States. That distance is 100 miles. And the external boundary isn't only the line with Mexico or Canada. It includes every coastline, the Atlantic, the Pacific, the Gulf of Mexico. Draw that on a real map and you don't get a thin desert strip. You get a band that swallows Florida entirely, Michigan, Maine, Massachusetts, Hawaii, 9 of the 10 largest cities in the country, inside. 200 million people living within the legal reach of a definition most of them have never heard of. That definition was never voted on by Congress. No senator proposed it. No representative debated it. It was written by bureaucrats. And the reason they picked that number is the part of this story that should make you stop. The DOJ wasn't trying to quietly hollow out the Constitution in 1953. They were solving a practical problem. Border agents needed to pursue people after they crossed. Someone walks over the line, disappears into the countryside. How far can an agent chase them before they vanish into a city? At 1950s road speeds, 100 miles was roughly the limit before a fugitive became unfindable. So the DOJ wrote it down as a reasonable distance, a working estimate, the kind of number that gets written into a handbook and revisited when the world moves on. The interstate highway system arrived. Coastal cities tripled in population. GPS made the original pursuit problem nearly obsolete. And the 100-mile rule sat exactly where it was, a car speed estimate from the Eisenhower era, now governing the privacy rights of 200 million people in the age of facial recognition and automatic license plate readers. Your rights at a highway checkpoint today are calibrated to how far a 1953 Chevrolet could drive before the road ran out. Nobody changed the number, but a frozen number is still a working number, and what it actually permits on the ground is where the stakes get real. Inside the zone, the Fourth Amendment doesn't disappear, but it bends in documented, court-approved ways, and the gap between what you assume your rights are and what a federal agent is legally permitted to do is wider than most people realize. Outside the zone, a police officer needs probable cause to stop and search your vehicle, a specific articulable reason to believe a crime is being committed. Inside the zone, federal agents need only reasonable suspicion. That's a lower bar. The legal formalization of a gut feeling. At permanent interior checkpoints, more than 35 of them across the Southwest, some sitting 50 miles inland from any physical border, agents need nothing at all. The Supreme Court ruled in United States versus Martinez-Fuerte in 1976 that stopping and questioning drivers here requires zero individualized suspicion. The court called the intrusion minimal. You're driving home from the supermarket in Tucson, not from Mexico, from the cereal aisle. The highway passes through, a checkpoint. The agent looks in your windows, asks where you're heading. You haven't done anything wrong. That stop is entirely legal. That is the 100-mile zone doing exactly what it was designed to do, and the zone is deeper than even that. Felix regularly covers political videos like this. Subscribe so Felix can run for office. There is a smaller zone nested inside the 100-mile one, and this one reaches into something most Americans consider completely untouchable. Within 25 miles of the physical land border, federal agents can enter private property without a warrant. Not your home. The courts have held firm there, but your land, your fields, your ranch, the unfenced portions of your yard. If you own property in southern Arizona or South Texas, an agent can walk that land, observe, and leave, without knocking, without asking, without notifying you afterward. Your no trespassing sign has no legal weight against a rule written before most of those. Landowners were born. This isn't a law school hypothetical. It generates real legal disputes across the border states every year, and it makes the question louder with every case. If this rule creates this much friction, why hasn't anyone in power revised it in 70 years? Felix is going to answer that. But first, the zone doesn't even stop at the coast. The 100-mile ring isn't a clean edge. It has pockets that appear deep inside the country, nowhere near a coastline or a desert crossing. The Supreme Court established what it calls the functional equivalent of a border, locations that operate like international crossings because people arrive from foreign countries. The main example is international airports: O'Hare in Chicago, Denver International, Dallas-Fort Worth. If you live within 100 miles of one of those, the same expanded federal authority applies. The result is something more, like a map a cat knocked a bowl of soup across. Overlapping zones with their own legal triggers, scattered through states most people think of as Heartland America. No single agency is required to publish where they are. No sign marks where one begins. Felix said at the start that the reason this exists would surprise you. You now know what the zone does. Here is why it has never been touched. Both parties spend enormous energy on the border, campaigns turn on it, and yet the 100-mile rule, the one governing the constitutional rights of 200 million people, is almost never mentioned by either side. That isn't oversight. It's convenience. Expanded enforcement authority inside the country, without warrants, without the probable cause standard that applies to local police, is a powerful and flexible tool. No administration, left or right, has found it worth surrendering. A rule written for one stated purpose can be stretched quietly to serve others. Flexible tools survive political change because they serve whoever is currently holding them. The zone also doesn't announce itself. No sign appears when you enter it. No letter arrives. It operates in the background, invisible, until the Tuesday afternoon you're stopped at a checkpoint coming home from the supermarket wondering what just happened. That is the moment most people find out the ground they've been standing on had different rules all along, and that is exactly how it was designed to stay quiet. Here is what Felix wants you to do with this. Look up whether you live inside the zone. The ACLU maintains a public map. If you do, learn two things. Inside the zone, a federal agent needs only reasonable suspicion to stop you. At a fixed checkpoint, they need nothing at all. Those aren't opinions or interpretations. They are the documented legal standards that apply to where you live. Knowing them isn't paranoia. It's basic civic literacy, the kind every American is supposed to have and almost none are ever given. Good Felix.